Gentlemen, welcome. Good evening, ladies and gentlemen, and welcome to the Township of West Orange Planning Board meeting, June 23rd, 2025, 6:30 PM in council chambers.
I don't think.
Okay, ladies and gentlemen, I'm going to ask that everybody be quiet. We're going to keep the air conditioning on because it's 98 degrees out. We're going to talk as loud as we can. I'm going to ask everybody who is speaking to speak as loud as they can, okay? If you can't hear, raise your hand. One of us will see you. They'll identify to me and we'll slow down. We want to get everybody heard, but I don't want to also turn off the air conditioning and have people unhappy about that, okay? Thank you so much. Okay, notice of this meeting was given to the township clerk and posted on the township bulletin board and township website calendar and sent to the West Orange Chronicle and the Star Ledger. This meeting has been properly noticed to the public in accordance with the Open Public Meetings Act. No new matters will start after 10:30 PM. May I ask everybody to rise for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Please be seated. The next planning board special meeting will be held June 30th, 2025 at 6:30 PM in person in council chambers. The next planning board regular meeting will be held July 2nd, 2025 at 7:30 PM via Zoom. Roll call, please, Yamilet.
Mr. Alpert,
Here.
Mr. Cardoza,
Present.
Ms. Staffer. Here. Mr. Klein. Mr. Noberling. Mr. Wilks,
Here.
Mayor McCartney. Present. Mr. Guarino,
Present.
Chairman Bago.
Here.
And
Thank you.
just for the record, Councilwoman Scarpa is joining us via Zoom.
Thank you. And Councilperson Scarpa will be joining via Zoom. Okay. Ms. McGovern, did any members of the planning board have any questions sent to you via email or in written form to be asked of any of the people speaking this evening?
No.
Thank you. Okay, Ms. McGovern, would you swear in the township professionals, please?
Okay, Mr. Hazel and Mr. Hess, welcome back. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. This evening, we have before us PB 24-01 West Essex Highlands Incorporated, Block 179, Lot 32, Zone IH1. Warner Road, the applicant is proposing a development of 496-unit inclusionary multifamily residential development on 120-acre property in the northwest corner of the Township of West Orange. Mr. Plucker for the applicant.
Hi, good evening, everybody. Brian Plocker from Hutch Manowitz and Plocker here on behalf of the applicant, West Essex Highlands, Inc. And tonight we brought with us back, as we promised, John McDonough, our professional planner, who gave affirmative testimony back in January. Mr. Affron, on behalf of the objector group, could not attend that evening, so we did promise to bring Mr. McDonough back for cross-examination, and he's here.
Thank you. Mr. McDonough, you understand that you are still under oath?
Yes, I do, Mr. Chairman.
We re-swear you in just because it was January, so 6 months ago.
Right ahead.
Okay, Mr. McDonough, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Okay. Mr. McDonough's credentials are well known to the planning board, but do any members of the board have any questions about his credentials? Seeing none, go right ahead, Mr. McDonough. Mr. Affron,
Thank you.
sorry.
Could I, one housekeeping matter very briefly? It's been brought to my attention, I know Ms. Scarpa has been attending remotely for personal reasons. It's been brought to my attention, she can't ask questions because of the nature of the link. Now, I know she's asked questions before. In fact, I noted in the record, put one to Mr. McDonough. It's our position that if possible going forward, we could get a link for her either to call directly in on the phone so she could ask questions. We feel that is, causing an absence of something in the hearings. So I'd like to ask that consideration be given for that for next Monday, if at all possible.
The problem is then we have to offer that to all members of the public.
Well, I don't want to take too much time now because we were trying to be efficient tonight. I just wanted to raise that. I could send a note maybe and we could follow up on the subject.
Okay, that'll be fine. We'll discuss
Okay.
that for the next meeting.
Thank you. Good evening, Ms. McDonough.
I'm just going to say one thing. all of the board members who are not available, like last meeting, there were a couple of board members who were watching it live stream because for one reason or another, personal emergency or whatever the case may be, couldn't be here. They were all advised, if you have a question that you want answered, bring it to me and we can ask that the witness be brought back to ask the question. And I received no information from any of the board members. It has happened in the past. A couple months ago, one of our board members, I remember Mr. Klein wasn't here. He came in, he said, I missed it, but I do have some questions because he had watched the tape. They're not foreclosed from asking questions. And,
And I appreciate that. I was simply raising an issue that was brought to my attention.
okay,
What Ms. McGovern is saying is logical. It wasn't something I was aware of. I just brought to your attention what I was told. And, I'm not suggesting I have any position one way or the other. I just wanted to bring it to your attention.
we're not trying to foreclose anybody from asking a question, and we are making that available to the board members for sure, but it has to be done in public where they're here and they ask the question. And that's what's been happening. Or if they send me a question and I relay it to it and can be done in public so that everybody can hear it.
No, I
Um,
appreciate that.
okay.
I just raised the issue as was brought to my attention. I did not have any more knowledge on the
Alright.
subject.
With respect to this witness, though, I know Councilwoman Scarpa already asked
Yeah,
her
she did.
questions, so
did.
it's really not an issue for
No,
tonight.
it's not an issue tonight.
Thank
I
you.
appreciate
Thank you,
your,
Sheriff.
your considering it though. Thank you. Good evening, Mr. McDonough.
Good
As you-
evening, Mr. Rath.
Thank you for coming back. As you know, I know you have another meeting and I appreciate you coming back tonight. I was unable to be here, so we'll try to be expeditious.
Thank you.
Now, you noted in your testimony that this satisfies one of the goals of planning, namely of providing affordable housing.
Correct.
But there are other goals in the MLUL, for example, that are normally to be incorporated into zoning ordinances. Isn't that true?
That is true.
Right.
Yes.
And could you state the other goals?
Sure. Well, there's about 18 or so under the land use law purposes.
Let me do this shorter then. So I'll shortcut. You would agree that among them are to, I'll select some. Section C, to provide adequate light, air, and open space.
Yes.
Section D, to ensure that the development of individual municipalities does not conflict with the development and general welfare of neighboring municipalities.
Yes.
To promote the establishment of appropriate population densities and
Yes.
concentrations that will contribute to the well-being of persons, neighborhoods, and communities.
Agree 100%. Yes.
Thank you. I'll skip some that don't seem relevant to our particular case. To encourage the location and design of transportation routes, which will promote the free flow of traffic while discouraging location of such facilities and routes which result in congestion or blight.
Yes. Agree.
To provide a desirable visual environment for various reasons.
Agreed again. Yes.
J in the statute, to promote the conservation of historic sites and districts, open space, energy resources, and valuable natural resources in the state, and to prevent urban sprawl and degradation of the environment through improper use of land.
Yes. Another purpose.
Yes, and there are others in the MLUL.
That's correct.
And I'm citing from section 40, colon 55D-2.
Two. Yes.
So it's not just affordable housing that needs to be satisfied as a matter of good planning, but rather these other elements must also be satisfied.
Correct. There are multiple purposes of zoning. As I understand the law, it's an applicant's burden to show and demonstrate that it meets one or more.
Now, I understand that you did not consider the impact of stormwater on the neighboring municipalities such as Essex Fells.
Well, again, my testimony relies upon the predicate of expert witnesses that have gone before me. So while I may not be an engineer, I am relying on the engineering conclusions that the site will not cause a negative impact from a stormwater standpoint on neighboring properties.
But you would agree, though, that impact on neighboring municipalities is a factor the board must consider under the MLUL.
Yes, zoning and planning does not end at property lines. Municipal lines, I agree.
Municipal lines, yes.
Yes.
Thank you. Now, you noted that the master plan in the town speaks to affordable housing.
Yes, the affordable housing, the housing element and fair share plan is one element of the master plan.
And in fact, nearly every town has one at this stage.
Correct, agree.
But the master plan also has other objectives and goals such as preservation of open space, protection of the environment, and other factors like that.
Indeed, yes.
So again, the fact that we satisfy an affordable housing aspect to the master plan doesn't mean the rest of the master plan is necessarily satisfied.
I agree with you.
Thank you. The MOUL, particularly section 55 D-2, is intended as guidance for incorporation into the zoning ordinances. Isn't that right?
That's correct. That's the preamble to the MLUL and the reason why this town and other towns get to zone in the first place.
So the zoning ordinances have to adopt those standards in some form in order to comply with the MLUL.
Yes,
I'm going to object to this line of questioning to the extent the zoning ordinance speaks for itself, and to the extent these questions are designed to attack the zoning ordinance, this is the wrong forum for that.
Well, if a zoning ordinance suspends virtually every environmental rule or all environmental rules, as the applicant has suggested, then it's actually not providing standards under section J, is it?
all I can say is that this zoning ordinance was found to be substantially consistent with the master plan when it was adopted back in, I believe, 2021.
Right, by the council. The council made that finding. And
But the planning board was in between making a finding that the zoning ordinance would not impair the intent and purpose of the master plan.
Again, I'm going to object. I believe this is the wrong forum to discuss the merits and legality of the ordinance. The ordinance was adopted, it was during COVID. I watched it. There was no legal lawsuit. There was no prerogative writ suit filed challenging the ordinance. So to the extent this line of questioning is seeking to challenge the zoning ordinance, the planning board does not have jurisdiction over that area.
actually, we're not here to challenge the zoning ordinance. That would not be the correct forum. I would agree with Mr. Plucker on that point. My purpose was different. Now, you cited the Pizzo-Manton case several times in your testimony. Now, and you said, well, Pizzo-Manton says that we look for sound planning in the ordinance. That was what you said, I think, in your testimony.
Yes, the essence of good planning, quote unquote, is rooted in the zoning ordinance.
Pizzo-Manton dealt with a case in which the Supreme Court found that the zoning ordinance actually specifically incorporated the different standards from the MLUL, such as avoiding steep slopes, avoiding wetlands, protecting the environment. Isn't that correct?
I don't recall that specific language in there. Again, I know there's always a nexus between an ordinance and the master plan and the purposes of zoning in the MLUL.
Okay, so I'm not going to press you if you don't recall that specific language. But if an ordinance actually abandons all environmental protection, as the applicant suggests this one does, then the board, even under Pizzo-Manton, has no choice but to look for the general welfare principles under the MLUL with respect at least to the environment, doesn't it?
I want to object to the characterization of the zoning ordinance as abandoning all environmental protections.
Well, then Mr. Plucker will identify where it does offer environmental protection if he's going to make
Okay,
that.
I'm gonna stop this for the moment. We're gonna move on because the ordinance is the ordinance. It's here, it's set in stone. You may argue this in another venue, but for right now, it's the rules we have to work with. So I would recommend you move on, please.
Well, if an ordinance requires environmental review of a site plan application, that means the board does have to, in fact, consider and explore the environmental impacts of the plan, doesn't it?
Well, there's a couple of forces at play here. The affordable housing regulations have specific language that talks about eliminating barriers to the provision of affordable housing. That said, I think we can certainly agree that it doesn't mean that an ordinance or a site plan can be violative of environmental protection regulations. I like this application for the reasons that I said before. Preserving 90 of the 120 acres, I think, is environmentally responsive and context sensitive. Buffers of 900 feet on one side is something I do this every night. I never see 900 buffers on one side and 700 feet on another side. This is a very considerate plan with respect to environmental preservation. In my view.
And are you trained in environmental protection?
It's part of the multiplicity of things planners need to consider is environmental planning.
Are you trained in environmental protection?
I
That was
am,
my question.
I am not an environmental scientist per se who could go out and delineate wetlands in the lake.
My question was simply, are you trained in environmental protection?
What is environmental protection? Is there a license in environmental protection? I don't know.
I don't think I need to have a licensed statute to underpin my question. It's a simple question. The planner has testified several times tonight, as well as the other earlier, that he thinks this is environmentally sound, this plan. So
And he
I'm
also
simply
said he
asking
relied on-
him, what are his credentials to make that judgment? It's a fair question.
But he has also testified that he has relied on the other professionals who gave testimony in this case, including the board's own professional.
Actually, what the gentleman just said was, in my opinion, he gestured to himself, this plan is environmentally sound.
Would you like to rephrase your testimony, Mr. McDonough?
I would appreciate if we wouldn't lead a witness into changing his testimony. That's not a proper question.
Mr. McDonough, have you had courses in environmental protection through your degrees?
Yes, my undergraduate is actually in environmental planning and design.
Okay.
Well, environmental planning, what have you studied by way of ecological science? Ecology.
We have ecology classes in school. We're also required and mandated to have continuing education as part of our licensure, our biannual licensure.
Let me be direct. Do you have a degree in ecology? In
I-
ecological
I
sciences?
do not have a degree in ecology.
Okay. Do you have a degree in environmental science?
No,
Do you have any degree in wetland science?
no,
Okay. Do you have any degree that would cover subjects such as air emissions and pollution?
no.
Okay. So you have some courses that touch on the environment as a planner, just as lawyers will have a con law class, but it doesn't make us all constitutional lawyers, does it?
Right. Planners are known as the great generalists because we rely on the specialty of others.
Okay. Thank you very much. That's very helpful. Now, you testified a few times that this plan is good because it doesn't allow for sprawl, to just generalize what you said. Now, there are three main buildings here, right?
Yes,
And there's a fourth, for some reason, none of us really know, there's an animal hospital in the projects. That's a fourth building, correct?
yes.
Now, Building D is pretty far off to the side on the project, isn't it? And there's a considerable space between that and the other two buildings, right?
Yes,
So that actually is sprawl in a very real sense, because we're not concentrating these buildings together. We're actually using up much more of the land to accommodate building C way off to the side. Isn't that true?
in my opinion, the applicant has done a good job of concentrating the buildings in pockets, developable pockets on the site and connecting them by a road network, which I believe is not sprawl. But again, that's consistent with centralized cluster planning.
Right, but if you have one pocket here and one pocket here and one pocket here, you are spreading out your development, aren't you?
The development is connected, but I would not qualify it as spread out.
Okay, so your feeling is that Building D, for example, is not sprawl, representing sprawl, and the animal hospital in the far end is not sprawl? You think this is a development that's compact and makes good use of the land? Is that your testimony?
That is my testimony, yes.
Thank you. You say there's a minimal land disturbance. That was part of you said that several times in your testimony, if you recall. Do you recall?
Yes, I do.
Well, let me ask you, this is going to consume about 1/3 of the site, isn't it?
That's correct.
Right. And in fact, it's going to, in consuming that 1/3, it's actually going to clear cut that entire 1/3, isn't it?
Yes.
Well, how is clear cutting 1/3 of a forest minimal land disturbance?
it's preserving, it's preserving in the public realm 90 acres of connected vegetated land, which may not otherwise be realized with a different type of design scheme, such as a residential subdivision.
Right, well, there was a residential subdivision proposed by the developer here in 2006, which was rejected by the board.
Yes,
Okay.
And which on the applicant prevailed in a prerogative writ in the Superior Court.
It wasn't built, was it? So what we have now is a plan that consumes 1/3 of the forest. Isn't that correct?
it does.
Now, did you hear the testimony of any of the objectors' witnesses?
Yes,
Now, they've testified, Mr. DeVito, for example, has testified that the actual effect of this project is going to create edge, which is going to consume virtually all of those two side forests that you say will be preserved. Do you remember that testimony?
yes.
And he says that what's going to be left is these tiny slivers of actual core forest on each side. And we have it, well, you don't have it here, but there's a diagram that shows two small residual fractions of forest that will be left as core forest. Now, if what he says is true, and virtually all of the core forest on this site is gone, except for maybe 7% or 9%, whatever he said it was, would you still say that's minimal land disturbance?
In my mind, yes. Again, in consideration of what could otherwise be realized on a different type of development scheme.
Well, how could you possibly do more disturbance than losing 91% of the forest?
Again, we're
Objection to the term losing 90% of the
Well,
ball.
why don't we do this? I can go to that seat and Mr. Plunkett can come here and he can cross-examine his own witness as he wishes, but it is my cross-examination.
Okay, and he's also not an ecologist. Mr. DeVito testified, we dealt with it. I asked him a couple of questions on cross. If he's gonna ask him ecological questions about core forest, let's ask him, voir dire, is he qualified to answer questions on the effect of the loss of core forest, as Mr. DeVito put it, or as Mr. Affron is putting it now?
Are you qualified?
He can't answer the question.
Well, first of all, it's not I who introduced the subject. It is Mr. McDonough who introduced the subject multiple times in his direct testimony. It is not I who has raised the issue that this project only causes minimal disturbance. It is the gentleman who's the witness who did.
But he.
So number one, that is directly within the scope of direct examination. And number two, because he's describing no environmental harm of any major consequence, my questions are relevant for that purpose as well.
He's asking
Mr.
about data, he's giving him data and asking him about questions with testimony that Mr. DeVito gave. And Mr. DeVito had different credentials than Mr. McDonough.
I must note that several times in Mr. McDonough's testimony, he said, we have uncontroverted expert testimony that says there'll be no major environmental consequences from this project. So clearly, Mr. McDonough reserved for himself the right to say our witnesses, the applicants, have all said in an uncontroverted manner, there'll be no harm here. Now, when I have a witness who comes on and says, no, we're going to lose 91% of the forest, there'll be virtually nothing left. Somehow that's outside of the scope of the witness's testimony, as Mr. Blocker would put it. Now, I would suggest, Mr. Chairman, that this is directly within the scope of the type of case they brought to you.
Go ahead. Ask direct questions if he can answer the question. If he can't answer the question, we'll get one of the other experts back to answer the question.
And I'll just renew my objection.
I've actually asked my question.
If this is going to be the subject matter, Mr. McDonough as a planner is here to look at the ordinance, look at the master plan. That's what he testified to. I guess we'll give Mr. Affron some leeway, but do we comply with the ordinance? Do we comply with the master plan? That was Mr. McDonough's domain. If he wants to ask him other questions regarding these areas, if he can answer it, let's have a blast.
I didn't introduce on the applicant's case repeated statements of no major environmental
Oh,
consequences.
okay, go right ahead, Mr.
This is not a matter of giving Mr. Affron leeway. It's Mr. Affron's right.
Go ahead.
Thank you.
You're welcome.
So would you call losing 91, the forest is virtually 100% of the site, isn't it?
correct. Yes, it is.
Now, would you call a project that leaves over only 9% of the forest minimal disturbance?
Again, this is a project that conforms with a zoning ordinance that is intended to protect the environment and has also passed muster through the stewards of environmental protection, which would be the DEP. So I would say, yes, it does advance environmental protection.
Well, I didn't ask you whether in your view it advances environmental protection. I asked you a simple question. If losing almost the entire forest and leaving only 9% is the effect,
I'm going to.
would that be minimal disturbance?
We are disturbing 27.5 acres out of about 120.5.
I
That
think
is
that
what the
this
plan.
constant interruption by Mr. Plucker is not.
Distorting the record.
No, the record from Mr. DeVito and his testimony has as much weight before this board as any of the applicant's experts, is that of the core forest, virtually nothing will be left. And he testified very specifically, and the witness said he heard that
In
testimony.
an area that's not governed by the ordinance.
It's got nothing to do with that particular question, whether Mr. Plucker is right or wrong, and I would dispute it. But the witness himself introduced repeatedly the testimony that there'll be no environmental harm, there'll be minimal disturbance. He said it over and over in his direct testimony. This was the core of the case that the applicant brought through Mr. McDonough. And I don't know why I'm getting constantly interrupted.
I'm just, this is cross-examination, I thought, based upon the direct testimony which was given back in January.
is.
And so now you're throwing in a witness who was after that period of time.
It's got nothing to do with it. This
Well,
witness said repeatedly,
You're asking him to draw conclusions from your expert, Mr. DeVito's testimony regarding what's left of the forest. So have you laid a foundation that this witness reviewed that testimony and agrees with that testimony? Because I
I
think
don't need
that's,
to ask if he agrees with another
but if
witness's
he's
testimony.
reviewed it, you're asking him, it's different than normal cross-examination
He's-
because you're going past what was asked on direct.
He said, well, this board chose to allow the witness to go forward when I couldn't be here. I can't help that.
I understand
We
that,
don't
but-
ignore what is
But
happening.
I'm suggesting that and I can't tell you what to do, obviously, but without that foundation, these questions are unfair.
The witness testified, he heard Mr. DeVito's testimony. He watched it, correct?
Heard it, yes.
Okay, he saw as much as any of us did.
All right, but it should be noted, this is not cross-examination from his January testimony. You're now taking it a step further. So this
I
is
could-
where the objections are coming from.
I don't think that matters. I am entitled to ask this witness whether or not losing 91% of the forest and leaving over 9% is minimal disturbance in his opinion. He said this is minimal disturbance, and I've now asked him a simple question. Is this, in his opinion, still minimal disturbance?
And that's a distortion of what's the application proposed.
This is not
It's his own
appropriate.
language or his expert's language.
If there's only 9% of the core forest left, is that minimal disturbance of this project, in your opinion, as a planner?
Yes, it's still minimal.
Okay. Based on your status as a planner, not any significant ecological training.
Yes, and my review of the zoning controls that establish limits of disturbance, establish limits of coverage and an application that complies. Let's talk about.
Lucky you. Oh.
If 9% of the forest is left as a core forest, and all of it is either clear cut or turned into edge forest, would you say that is the absence of significant environmental harm?
Good site design.
Excuse me. There's a difference between asking him questions that are to set a record outside of the planning board and the information that the planning board will use to make their decision. We've heard Mr. Vito's testimony. We've heard his testimony. You're asking questions
I
that,
can move on.
I'm sorry?
I'll move on.
Thank you.
The point was made anyway. I'll
Thank
move
you.
on. Thank you. You testified that the plan will incorporate abundant, robust landscape. That was your actual quote. Do you recall saying that?
Yes,
Well, what do you mean by that? I mean, where in these plans that we've seen is there abundant, robust landscape?
There are landscape plans that were included as part of the development application. There are many plantings throughout. I don't have the number in front of me, but there was a significant landscape plan.
Other than what you have just said, can you answer my question further, or is that conclude your answer?
Yes,
So you believe that the existing landscape plan is abundant and robust?
yes.
You also said this plan, I'm just paraphrasing here, but I'm sure you'll agree with my general reference, is one that will flow comfortably for people. Do you recall saying something along those lines?
Yes.
Well, when you said flow comfortably for people, what did you mean by that? You didn't explain it. You just gave us the conclusion. So what does it mean to flow comfortably for people?
I think what I said was the project has been designed to flow, function, and operate safely, efficiently, and comfortably. And there are multiple parts to that. Flow generally refers to the flow of traffic through the site, the parking capacity, the overall functionality of the site being designed in accordance with sound planning principles, most importantly, the ordinance.
So when you said flow, there was a lot more that followed that word. So let me just ask you what flow means in your usage. Does it mean the movement of people, vehicles, seamless movement? What are you referring to when you say
I think it
flow?
means all of the above, vehicular circulation, pedestrian circulation, movements throughout the site and through the buildings. The buildings are designed in a sound manner. There will be a comfortable, nice place to live.
Does it flow comfortably for pedestrians if you can't walk on a sidewalk to leave the development?
Again, I think there's good connectivity between where vehicles would park, between the units and the overall site.
Is there good connectivity for people to walk out of this development and go into the rest of the community?
Do you mean to the south or to the north, outside of the bounds of this?
Well, assume that the north is undeveloped. They're not going to walk across what's left of the forest. I mean, south, because there's an association down there, hundreds of houses, there's other things. Now, if people want to walk out of this development, does this flow comfortably for the pedestrian when there are no sidewalks?
Yes, I don't see, again, based on the testimony on the record, I don't see any substantial consequences with the way the pedestrian circulation system has been designed.
Yeah, and I'm going to object to the comment that there are no sidewalks. We are seeking an exception for RSIS in one location for sidewalks on both sides of the street. But to make the statement that there are no sidewalks proposed is misleading.
I meant, and I think it was quite clear from the context, leaving the development, there is no sidewalk. That's quite clearly what I said.
I don't know what leaving the development means.
Can you walk out of this development and stay on a sidewalk and go into the neighborhood below?
Where?
The neighborhood below.
And where are you referencing sidewalks or lack?
All right, I'll tell you what, if the witness has doubts about my question and its meaning, the witness can ask. I'm now in the process of examining Mr. Parker. I think we should stop and let me continue with the witness because there were some reasons why we wanted to be expeditious. May I continue?
Right ahead.
Thank you. Now,
Mr. McDonough, if you don't understand the question or don't have an answer, the answer is I don't know. And that's what.
Understood, Mr. Chairman.
yes, but Mr. Parker should not be saying he doesn't know before he says it.
Agreed.
Thank you.
Thank you.
You said the community has the right to create zoning districts. That was actually a quote I took from the transcript.
Yes.
Now, by that you mean, of course, the community under our state laws has the right to zone and create zoning within the community.
Yes.
Now, the normal process, you would agree, would be that someone proposes a zoning amendment. It goes to the planning board for.
Mr. Efron, there's a
consistency.
zone plan. We're going to move on. There's a zone plan in place. We're going to move on. His understanding of how it works is not relevant to the planning board.
Well, I didn't testify that the community has the right to create zoning districts. He was saying that this was, well, I'll go further. You would agree in this case, this is the unusual situation where a lawsuit was filed by the developer and that this zoning district was the product of a settlement in that case. Isn't that correct?
I would not agree with the phrase that this was unusual. This happens throughout New Jersey.
That's not exactly the same as the council initiating zoning, but rather here it did it under the threat of continued litigation.
Well,
Isn't that
well,
what you-
I got that one. I don't know what happened. The Superior Court was the mediator. It is outside the purview of the planning board. And in fact, the resolution specifically states the planning board was not participant, so we only can discuss the zone plan and the master plan that's available to us now. We're gonna
I
move.
was really following the direct testimony.
Okay, thank you.
You said that there's the general welfare aspect of zoning.
Yes.
Right. Now, there's lots of things we speak about: public safety, public health, public welfare. What did you understand the term welfare to mean in that context?
Sometimes we refer to purpose A as the great catch-all phrase because it encompasses many beneficial aspects of planning, but the general welfare, the public good. In there, I included affordable housing as being one of the top tier goals of our zoning laws, and the provision of affordable housing of being of paramount public interest. It's everywhere. It's a requirement everywhere.
You would agree affordable housing is not the only thing that embraces the general welfare.
Totally agree with you. I probably said this before. Planning is all about balance, striking that balance. There are tremendous forces on municipalities to provide for affordable housing. There are certainly environmental protection forces as well. It's about balance.
Thank you. I just want to clarify. So the general welfare embraces environmental protection and those other issues, correct?
Yes, agreed.
Thank you very much. I appreciate that. Now, you said in your testimony, I'll quote from the transcript, you, meaning you're referring to the board, you have testimony through your own environmental expert that there will not be any substantial environmental impacts. Close quote. You were referring to Mr. DeFeo when you made that statement?
Yes, and I believe that was the hearing before I actually testified. Yes, it may have been that same night.
Okay, so your view is that Mr. DeFeo affirmatively said there will not be any substantial environmental impacts?
That's correct. At the time of when I testified, yeah.
Right, so that was your interpretation of what Mr. DeFeo said?
Yes.
Okay, thank you. And when you said the board has uncontroverted expert testimony about the absence of environmental impacts, that was obviously when the applicant was presenting its case before any objectors
That was
testified.
based on the evidence before me at the time of my
Right,
testimony.
so uncontroverted might have been jumping the gun a bit, right?
Yeah, again, at the time of my testimony, yes.
Okay, thank you. You mentioned in your testimony that the application here refers to, quote, the quote, settlement agreement with the neighbors there, close quote. Now, when you refer to neighbors, who are you referring to?
I was probably talking about Cusick when I was referring to the RSIS exception.
Yes, that's the section in the transcript where I'm quoting from. So when you refer to neighbors, who are you referring to?
I don't remember the name of the organization offhand, but there was an agreement with the, I believe, the association to the south.
Right, so an association signed an agreement, but you don't know if individuals signed on to that, do you?
I don't know the details.
And do you know whether the association had legal authority to make commitments on behalf of individual homeowners?
I
I'm sorry,
don't-
that's out of his purview. That's out of his purview. He's here as a planner.
Excuse me, I know it's out of his purview. That's why I was surprised he said it in the first place. So I'm cross-examining to be certain what knowledge the witness had.
And the settlement agreement speaks for itself.
Well, the witness here was speaking for it. He was saying this settlement agreement is an agreement with the neighbors, meaning the people who own homes and live there. And I'm asking why he said that. I'm
The
perfectly
planning board, I
entitled
will
to do it.
state for the record, the planning board has a copy of the settlement agreement. They've read it, they understand who the parties were. and let's go back to the zone plan.
I must point out that the applicant's witness offered many, many statements that fall in the exact category, Mr. Backup, you're suggesting, is not really within his purview. Yet it's an impression is left from that testimony based on things that really weren't in the witness's purview, and that's why
The-
cross-examination is
board,
necessary.
Understands what's been going on, and the board understands that there was a settlement agreement, and we are not participant in it. The outcome of the settlement agreement is what we're working with.
Well, I don't know if you know what everyone on the board is thinking, of course, but my only point was to test what the witness meant by saying the neighbors had settled. Because if that implication is left with the board, it's a false one.
Okay, do you know, Mr. McDonough, do you know the term neighbors, what that referenced?
I don't know I don't know the details of the settlement agreement.
Thank you.
Thank you.
You mentioned that unless the RSIS de minimis waiver is granted, there'll be an undue hardship because of peculiar conditions pertaining to the development in question. I'm quoting you actually. What undue hardship and what peculiar conditions were you referring to?
I have to remember the context of what I said, but again, I was reliant upon the testimony of our expert traffic consultant that the design with the loop less than the 1,000 ADT, due to the closure of Cusick, would not violate the intent of the RSIS, and that language is in there.
Right, but I'm asking, well, no, if the language is in there, then there has to be a showing of evidence to support those conditions. So I'm asking, what is the undue hardship and what are the peculiar conditions if you know? Now, you use those phrases, so I'm asking what you meant or what you know about that.
I'll fall back on the settlement agreement, that the particular or peculiar circumstances or that there was an agreement in place, and that would cause an undue hardship to break that agreement.
And if I can probe further, there would be an undue, are you saying that to strike that? I'll move on. Thank you.
Okay.
You've answered my question. I just need a moment to continue on my notes. They were partly written while I was in motion on the highway. So it's taking me an extra minute or two.
Go ahead.
You referred to this plan as satisfying the standards of the complete streets concept in the town. Do you recall that testimony?
I do.
Now, you also testified that, well, let me get the exact reference, I'm sorry. You also said you did not know the distance that one would walk from the development to the nearest public transport. You remember saying that in response to a member of the public's question?
I do, yes.
Okay, and just one more moment, please. You also said that you asked, are you aware that this property is locked in by other properties in order to get to any sort of mass transit? And the question went on, and you said you didn't know that one way or the other. Do you recall that?
I know that the property is central to development around it. So yes, to get to, I don't know if there's any transit on the edge, but my assumption is you would have to go beyond the property borders to get to transit.
Well, doesn't complete streets really, well, what does complete streets mean in your understanding?
It's to ensure positive pedestrian circulations, bicycle circulation and amenities, and vehicular.
So if you don't know how far one has to walk to the nearest mass transit, and if there's no sidewalk connecting the development to facilities outside of it, do you really feel this is complying with complete streets?
In my view, this is a pedestrian friendly, bicycle friendly, and again, vehicular safe plan.
You base that on, say, Mr. Penke's testimony and others.
Pretty much all of the witnesses before me, Mr. Anderson and Mr. Penke, yes.
Okay. So based on what you heard from them, you feel that it achieves those safety issues.
I do.
Okay. Do you know if strike that? I'll move on. I'm a little puzzled by something. You said that the planner, when he or she does their work, looks comprehensively at the application.
Yes,
Yet you also said, I think it was a response to Mayor Davis's question, that you had not examined the impact of stormwater on Essex Fells that would arise from this plan. Remember that?
I have not personally done a drainage analysis, no. I know there's a pretty thick engineering document out there.
Yet, if the MLUL says in subsection, I believe it was D, that the board and the ordinances, of course, must consider the effect on neighboring municipalities. And you as a planner have not done that analysis. How could you say you've done this comprehensively?
Well, again, I'm reliant upon an engineering study that has been signed and sealed by a professional engineer who is qualified to perform that study, coupled with sworn testimony under oath by that same expert.
But in your comprehensive analysis, you did not do that review yourself.
I don't know how to do drainage calculations.
Okay. Well, I didn't ask about the calculations, but I did ask about the effect on neighboring communities. Did you do any analysis like that at all?
My analysis focuses on what the engineer says.
Would it be good planning for a site plan application to come before a board and not have any sewer plan?
You mean stormwater plan or sanitary?
No real sewers.
No, again, a network could be, a final design of the network, the size, can all be part, in my mind, an outside agency condition of approval, such as a MUA.
Is it sound planning for an applicant to ask a planning board to approve a major development of this nature with no sewer plan? Yes or no question. Is that sound planning?
Yes, it is not atypical for certain aspects of a plan to be conditions of approval through an outside agency. A shovel doesn't get in the ground until those details are worked out and designed.
My question wasn't about certain aspects in the abstract. It was a simple question. Is it sound planning for an application to go before a planning board of this size and scope with no sewer plan?
I'm going to object to the extent the question insinuates that there is no sewer plan. That
I haven't seen the sewer plan. I haven't seen a sewer plan. The engineer hasn't seen a sewer plan for the town. It was made very clear that that's an issue here. If there's a sewer plan, I'd like Mr. Plucker to present it.
I think there's a confusion between a sewer plan for the site and what may be happening offsite, which was discussed with Mr. Anderson and the township engineer.
Is there any
During
plan
the-
to move sewage from this development off the site at present before this board? The answer is no. So Mr. Dunn,
I object to that characterization.
is there such a plan?
I don't know.
If there is no such plan, would you say that reflects sound planning?
I would say that that is not out of the ordinary for a project of this magnitude to defer that to a future phase.
And your view is that would be sound planning to have that
Yes.
absence?
I believe that's cooked into the MLUL process.
Oh, okay. If a development is going to introduce 1,700 daily car trips, or more than 1,700, to a community where there's only one way out and one way in, and that will be going through an existing neighborhood, the association, would you still say that that plan does not reflect undue sprawl?
Yes, I would still say that.
Cars are part of sprawl, right?
They certainly are.
Right.
Yes.
And the more cars we put in our environment and the more traffic we impose on our communities by more and more development, that's all part of sprawl, isn't it?
It's a subset of sprawl, yes.
It's part of sprawl, right?
It is a part of sprawl.
Right. Okay. And you would say the addition of almost 2,000 daily car trips into this one-way access and ingress through this existing neighborhood is not adding significant sprawl to our community?
I would, all things considered, I would not say that the traffic alone would rate this project as a sprawl project.
Well, I didn't ask alone about the traffic, though I think one could say that. When you add all this extra traffic and we add the destruction of this vast forest, and when you add the 1,200 people who will now live here and the multiple buildings spreading out through this forest, would you still say there's no significant sprawl?
I would, again, I rely upon a licensed traffic expert who looks at the carrying capacity of the road network and the transportation infrastructure that's presently in place, and that there is adequate capacity to accommodate that type of volume.
And the town zoned it for this density.
I'm sorry, what?
The town zoned this property for this density that is proposed.
I am simply asking the witness who went out of his way repeatedly to tell us there's no sprawl here, whether in view of all of these factors, he stands by the proposition that this project does not contribute to urban sprawl.
And I still stand by that statement.
You mentioned that the traffic engineer spoke of the traffic. But the question of sprawl and blight is within the planning profession, isn't it quite, isn't that true?
Yes,
So you can't really defer to what the traffic engineer says on this question. You need to have your own substantiated viewpoint, isn't that correct?
again, it relies upon the predicate of the witnesses before me. Traffic generation is certainly a consideration. Land disturbance is a consideration as well. All of that which is proposed here is within the confines of what the ordinance contemplates.
Well, then why'd you bring up sprawl? I mean, if the ordinance contemplates this project, then why did you bother to tell us there's no sprawl coming from it? It wouldn't matter, would it? As Mr. Plucker says, the ordinance says you can have this density. So why did you then tell us that this doesn't create excess sprawl? If the ordinance says we can do this, why did you go to the trouble of trying to persuade the board that there's no sprawl?
Because the purpose, in my mind, the purposes of the zoning ordinance are laudable as a deterrent to sprawl, compact development. And the efforts of the applicant are laudable for following the laudable goals of the ordinance.
So basically you're saying because the ordinance allows this, there's no sprawl.
And saying the purpose of the ordinance is like laudable again. As a deterrent to sprawl.
Well, so you say that this project deters sprawl and that's laudable.
Yes, we have a problem in New Jersey. We have a demand for housing, for affordable housing. That is imposed, that is mandated on communities. Communities have to pick their spots. And again, this has been a well-vetted process that landed us to here. An ordinance that went through all of the procedural requirements that needed to, and then an applicant that has essentially followed that to a T.
Well, you know perfectly well that when there's a settlement agreement in an affordable housing case, there's going to be an almost automatic approval of the zoning change.
I got it. I got that one. Let's not go there. Whatever the court does is above the pay grade of this planning board. Okay, so.
Well, then the
however-
witness shouldn't
however
be
it came down-
speaking to the fact, excuse me, every time I ask a question, the witness goes back to the laudable objectives of the very well-conceived plan that followed all procedural bases in creating the zoning ordinance. So he's constantly telling you, all of this is done in the perfectly normal, legitimate way, and yet Mr. Plucker then rises and says, don't you dare cross-examine him.
You can cross-examine him I think the board is picking up on things.
I got it.
Try, give us a little.
Quick,
credit.
move on.
Can I just clarify my statement?
Yeah,
My
go right ahead,
objection
Mr.
is
Clark.
not that Mr. Akron can't cross-examine Mr. McDonough, but it said that this board is basically bound to an automatic approval, and I don't agree with that statement at all. So I think it was misstating what this board can and can't do in the duties and jurisdiction and obligations of the board. That was my objection.
Well, actually, Mr. Plucker and I are in full agreement. The board does not have an automatic approval obligation. I'm glad we agree on that. I was actually referring to the sort of automatic.
We agree
zoning-
with that too. We agree with that too.
I'm glad this is the point of doing this. We get to a point of agreement and it's good.
Let's get beyond sprawl now. Thank you.
I think we can avoid the arms of sprawl. We're coming to the end. May I just have one moment, please? Mr. Chairman, that covers our cross-examination. I thank Mr. McDonough. I hope he's able to get to his, there may be more questions in public, I don't know, but I hope he can get to his next meeting.
The
on
board
time.
and the public have had questions of Mr. McDonough previously, so we want to thank Mr. McDonough. Unless Mr. Plucker has any questions. Okay, good.
No, none.
Thank you. The public
One-
had questions. I'm sorry. The public and the board had questions already. This was just for Mr. Efron to ask questions. That was it.
I do have one quick question,
ahead.
housekeeping matter. Been brought to my attention that. Let me rephrase that. Our plan is expected next Monday. Excuse me.
Okay.
Regardless of when our planner is coming, do we know when the audio of this day will be published on the website so our planner can hear it? That's the only thing. When does this get put up on the website, the audio? 'Cause I want to make sure my planner can hear it. Great. Thank you. That's, thank you. Yes, Jamile stated that, if I may say Jamile, that the audio will be published tomorrow on the board's website
Via link.
via link. Yes. That concludes what we have. Thank you very much.
Thank you.
You have no more witnesses, right, for tonight?
No, we talked about
that, and we'll
do that.
So I guess.
We formally announce.
Yeah.
I know we did it.
Yeah. Monday.
You're at 6.
Okay. Okay, ladies and gentlemen, here and on Zoom, we want to thank you very much again. We want to state for the record that Councilperson Scarpa was watching the meeting via Zoom. The next planning board special meeting will be held June 30th, 2025 at 6:30 PM in person in council chambers and visible on Zoom. The next regular planning board meeting will be held July 2nd, 2025 at 7:30 PM via Zoom. Do I have a motion to adjourn?
So move, Mr. Chairman.
Second? I second. All in favor?
Aye.
Opposed? The ayes are above the nose. Thank you very much. Have a wonderful evening, everybody.